at attypip.com.
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Open on Saturday mornings, just for you. If you have a legal question, all you have to do is call our toll-free number. Hey, your question can be just about anything. Doesn't even have to be a legal question. I'd like to help you if you just have a problem of some sorts. But if you have a legal question, most commonly those are on wills, trust, estate planning, family law, real estate law, just everyday problems that come up in the workplace or next door neighbors. If you have a legal question, you have a toll-free number, 877-943-9673. 877-943-9673. The law office is open. Always like that first question coming in. I could talk for the 50 minutes or so. We have a straight run, by the way. If you notice, there are no commercials on my run here. It was just straight legal information, trying to help solve problems and get you pointed in the right direction. No commercials. You have a toll-free number, 877-943-9673. Phone lines are open. Would like to say Rush Limbaugh, I know, passed away this past week. What a loss. I mean, every time I would be in the car when he was on, I would want to listen to him. And I think he was just, and actually I look back and he started his radio shows, I think, in 1988. I actually started mine, Ask an Attorney show. I mean, it's nothing like a show that he has, but I started mine in 1984 and have done so continually every week, usually on multiple stations. I was nationally syndicated for a while. On Ask an Attorney, same host, same format since 1984. But Rush certainly inspired. He helped the AM talk radio and FM radio bands thrive and survive, and he was well liked and well respected, I think, and just sorry to see him go. Let's go to Josephine in Kingsport.
Kings Point. Good morning.
Okay, good morning.
I have a question. When writing out a check, what's the reasoning behind using the black ink or the blue ink?
Well, is somebody requiring you to do one or the other?
Yes. Well, I usually write everything with black ink, but I don't remember why he mentioned the blue. I forgot what he told me.
The banker?
That's a good question, too. Who was it?
Josephine, I don't think it makes very little difference. I know on ballots and things like that, the government likes for you to use black ink.
Okay.
To go through the machines, the voting machines and counting machines and so forth. They say black ink.
Right.
I think if you used blue and it was dark enough and firm enough and strong enough, it would be fine. But there are a few places that kind of request black. I think it would be a legal document if you signed in black or blue, so I really don't think it makes too much difference there, and I really don't think it makes difference in with a bank.
I don't remember what I was told about the blue. I've been writing everything with black.
Yeah,
but then something about the blue was mentioned, and
yeah,
I don't remember what he said.
Josephine, I don't think it makes a difference. So
no difference.
I hope you have a great day, though.
Yes, thank you.
Thank you. Hey, you're listening to Ask an Attorney, all about Florida law. If you have a legal question, all you have to do is call the toll-free number, 877-943-9673, 877-943-9673. You got something on your mind that really bothers you? Something you just wonder about, like that first caller? Hey, I'll be glad to help you. And let's go to Will in Tampa.
Hey, good morning. I've got a situation. I'm retired, 69 years old, and I had a situation where I lived here and I had a divorce in Texas.
Okay.
I had handwritten receipts from my ex that I paid my child support, handwritten receipts for every month till the child was 18. When my child turned 19, I got a letter from the Texas state saying I owed $105 in back child support with interest and penalties. I sent them copies of the receipt. Didn't faze them at all. I kept getting the letters that I owed $105. When I got old enough for Social Security, they started taking $600 a month automatically out of my Social Security. I never attended a court hearing, never had anything. They just started taking the money out automatically. They did that for about 4 years. Oddly enough, I prayed over it. I made one phone call and got it lowered to $300 a month. I did go to court with an attorney before that, and it made no difference. Basically, the judge said that her agreement and my agreement, paying like that, had nothing worthy in Texas law because we didn't go through the courts. Do I have anything that I can do here? Do I have to? What would you recommend?
How do we go from $105 owed to $600 a month?
No, it was $105,000.
Oh, $105,000. Okay.
That's with penalties, interest, like the IRS does. So they started taking $600 a month automatically. They did that for about 2 years. Then I hired an attorney in Texas, went to court, and the court.
Are you talking about they, meaning the IRS?
No, the child support system in Texas.
I see.
Yeah, they take $600. They were taking $600 a month out of my Social Security automatically. And like I said, I hired an attorney.
Right.
Go ahead.
Yeah, so you're gonna. I can't tell you anything but to get an attorney in Texas to help you with that. I mean, it sounds wrong. Your attorney should be able to straighten it out and help you. I don't practice in Texas, so I'm not licensed there, so I can't really give advice about Texas law and Texas courts and what's going on. It sounds like if you can prove you made the payments and you've given that to your attorney, that should help solve the problem. And why it's not, I don't know. It's going to be up to your Texas attorney to get that figured out for you.
Yeah, well, that's what I thought too. But Texas law says that no one person or persons can change or alter child support without a court order. So all that I did was.
Well, but you said you had made the payments directly to her and had receipts. So I assume that you paid what the court had ordered to her and have receipts for that. Are they saying they demanded the payments to be made to the court and the court would give her the money?
Right.
I see. And they're saying you didn't have a right to alter that, and your receipts don't mean anything.
Exactly.
Well, I'm not licensed in Texas, so I think that you could show the receipts and that should mean something. But you're going to have a Texas attorney to advise you on that.
Do you have maybe a referral of a Christian attorney in Texas that could help me?
You could Google the Christian Legal Association, and there are a couple of national Christian groups that you can probably find an attorney that's located in that state to help you.
Okay, now I don't have a computer or anything like that. So how would I go about doing that? Could I do that on a smartphone?
Yes, if you can get internet on your smartphone and go on the web there, that'd be fine. Don't you have a family member that might be able to help you that has a computer?
Okay. What kind of website or whatever could you refer?
Well, the Christian Law Association. You Google something like that. That's a national organization.
Okay. All right. And one other question. It's kind of stupid, simple, but it is a problem. Is there any law that says people have to keep their cats indoors at night, or why does everybody let their cat out at night?
No, I don't think there's a law you have to keep your cat in your house. You might have to keep the cat in a fenced area or a contained area, but not necessarily in your house.
Yeah. Well, somehow they like to get around my house and do their thing at night at 3:00 in the morning. And I didn't know if there's not like a leash law for dogs, but with cats, people just let them out all night. There's nothing you can do about it.
You can call the animal control, see if they can help you.
Thank you so much for your help.
All right, Will, thank you. Let's go to Connie in Jacksonville. Hey, Connie, can I help you?
Yes, I have a number of trees that have been trimmed on the business side. I'm surrounded by businesses. I'm zoned residential, commercial, and the trees are leaning so horrible on my roof. My insurance is not willing to cover me. So how do I have a responsibility? They're huge, and I have lupus, and I don't know if I have legal anything, because they trimmed them many years ago on their side and left this whole side. I took care of a lady here. I did care work for her for 20 years.
Well, it sounds like you might not have the money to trim the trees yourself, but you have the right to trim up your property line. And they have no other obligation to assist you. So what I would probably do in your case is I would write a letter pleading with them, telling them your medical condition and your financial condition, that you don't have the resources to even have your house insured because of overhanging tree limbs of their trees. You can't get insurance. I would write a letter pleading with them to take care of their trees overhanging your property and see if that works.
Okay. All right. Well, I appreciate your help.
That's what I would do.
Thank you so
if I were
much.
you. Okay. All right, you're listening to Ask an Attorney, all about Florida law. Some of my answers are, what would I do? Not necessarily a legal answer, but here's what I would do, and I'll be glad to share with you what I would do in certain circumstances. Hey, if I can help you, you have a legal question, a legal problem, just something nagging at you that you would like to be a little different in life, give me a call. Maybe I have a solution for you. I'd love to help you. 877-943-9673. Phone lines are open. 877-943-9673. Let's go to Jeff in Bradenton.
Hi, Joe. Good morning.
Good morning.
Okay, here's the situation I got. My son, name's Jacob. He lives in Ocala. Apparently, a developer had bought up 3 acres of property directly behind his home. He lives on a cul-de-sac. It's on the very end with a retaining pond at the very end of that cul-de-sac. And he cleared the property of every tree, bush, shrub, everything is gone now. He's going to develop it. But, of course, Ocala, you know the terrain in that area, it's a little higher than my son's house. And the back room of his house apparently was a screen room, which the elevation is small or lower than the home itself, slab. Well, it rained last week very hard up there, torrential downpour, and it flooded his back room, which is his two sons' bedroom. And, of course, 3 inches of water. And I advised him, being in construction, he had to take out the drywall at least 3 feet high, as far up as it was dry, because of, potential mold problem, that he didn't want to have that, obviously, with the children living back there, sleeping back there. And he had to take out the insulation. So he talked to the developer, and he wasn't really willing to do anything to mitigate the cost of having to repair his back room. So he's approached the county about it. The county really says he doesn't have anything he can do about it because, the guy did everything with permits and everything was legal to that point. So, and apparently the developer's not willing to dig a drainage canal or ditch or something of that sort to, mitigate the water away from my son's house and into that retention pond. So I told him I'd try to get a hold of you this weekend and see if he had any other action he could take.
I don't know of any other. If the developer did all the proper permitting and county inspected it and approved it, and that's what you wound up with, I think it's going to be a hard course of action to try to sue the developer to do something. But that's probably your only chance, is to meet with an attorney who can develop a strategy on how this is all wrong and detrimental to your son, and the county shouldn't have done this, or the developer shouldn't have done that. And I don't know. I think it'd be a complicated, costly lawsuit if that's what it.
Yes, that's what I told him. The first thing was, get a hold of you or get a hold of an attorney. If he doesn't have the money for that, I mean, he's not destitute, but he's, it's just, it's just.
Well, it's going to probably happen again, though.
Yeah, it's most certainly going to happen again. Most certainly.
Can he develop his own drainage ditch to divert the water?
It looks like it's going to. That's what I told him, that we'd. Sounds like we're going to have to rent a trackhoe and just dig our own diversion canal, if you will. You could meet with a real estate litigation attorney to see if they could develop some cause of action to make the developer do it, or point out to the county they were wrong and get some relief from the county. But that's really your only. Either fix it yourself or hire a real estate litigation attorney to develop some strategy of where they would be forced to correct the problem. Yeah, it really surprised me that the county can't look at that and say, yeah, that is definitely an issue. And how they approved it is beyond me. But,
well, a real estate litigation attorney might have some way to go through the county and get some type of order that gets higher up to look at it, perhaps. I don't know. You're not going to know until you meet with somebody experienced in real estate litigation that handles matters like that. So.
Exactly. Yes, sir.
All right,
okay.
Jeff.
All right. We're going to pursue it. Thank you, Joe.
Thank you. Hey, you're listening to Ask an Attorney, all about Florida law. Hey, you could watch Ask an Attorney this morning on WeBeamTV.com. You could go to WeBeam TV. We're streaming the show live on video there. Also, we're posting it live on Facebook, Ask an Attorney, and you have multiple ways to follow Ask an Attorney, all about Florida law. If you'd like to call the show, 877-943-9673. That's 877-943-9673. Phone lines open right now. Let's go to Cecilia in Tampa.
Good morning, Joe. First-time caller, highly recommended. I work for a small business in the Tampa Bay area, and we had one account that totally skipped out that owes us over $4,000, slightly over. Relocated the company currently, from my understanding, works out of a residence. I like to go down there. I'm going to be in the Fort Lauderdale area, and I like to go down and knock on his door and try to collect the money. Do I have legal recourse just to go knock on the door? What is your recommendation?
Yeah, there's no reason you can't go knock on a door. I mean, there's no law against knocking on a door for sure. So yeah, you could try that. Other than that, if everything else fails, you could go to small claims court with a matter that size.
Okay.
And then sometimes it's easy to get a judgment against somebody in small claims court and then still have to fight to get the money. But then at least a judgment gives you the right to take a car or some bank. You can put them in discovery, it's called. So you get them in a deposition where they have to disclose their assets. And once you have a judgment, you have even more power to try to collect the money. It just depends on whether you want to spend your time and money pursuing someone who might not have any money. I mean, sometimes the judgment's all you get, and it's hard to collect on that too sometimes. But yeah, you can go knock on the door.
Okay, all right.
Just don't go into don't try to go into a place that has a locked fence, or something like that to get to the front door.
Okay.
But other than that, think about it. UPS, FedEx comes to your door all the time, right?
Correct.
And you have little kids knocking on your door trying to sell you Girl Scout, cookies. I mean, people can knock on your doors. No problem with that.
Okay. All right. Well, thank you for your guidance and your answers.
Thank
Have
you.
a good day.
All right.
Uh-huh.
Let's go to Joseph in Waimama.
Hello.
Hey, Joseph.
Hi. My house, I have my house on for sale, and the buyer put down a deposit and did the inspection report and all that stuff. And we did a lot of repair, which we have to do anyway. And the buyer now has canceled. And canceled due to the fact that the the lender, has said that there's no source of income.
Mm-hmm.
The realtor told us that the individual was pre-qualified. But my question is,
was that, first of all, was the contract, the contract to buy the house, was that a contingent contract based on him being able to get financing?
No.
It was not contingent?
No, it was based on that the person was pre-qualified.
Did the person put down a deposit?
Yes, the person put down a $2,000 deposit. That's my question.
Yeah, and what does the contract say about if he cancels the contract about the deposit? There's a paragraph in the contract, the real estate contract, most likely, that says if the buyer defaults, this is what happens to the deposit. Have you looked at that paragraph?
No, I have not.
Well, there lies the answer, right in that paragraph.
Okay. Because a lot of people are telling us that, that have sold houses near us recently, that those proceeds are supposed to come to us. But I guess in our contract it doesn't say that. It probably says
who's holding the deposit?
It was put into escrow.
Okay, by the real estate company?
Yes.
And what does the real estate company tell you they're going to do with the deposit?
I'm not sure. I got to check on that.
Yeah. Well, when you ask them and they tell you and you don't like the answer, if that's what happens, ask them to show you the paragraph in the contract that allows them to give it back to them.
Okay.
There's one of those probably on the back side of your contract in really small print. There's a paragraph that deals with the buyer defaults, what happens to the deposit.
Okay. Well, thank you very much.
All right. And we have an office in Sun City Center very close to Waimama there. So if I can help look at the contract or help interpret it, I probably wouldn't charge anything just to take a look at it and find that paragraph myself. If you don't have good luck in your pursuits there, I'd be glad to look at it for you.
Well, thank you very much. I enjoy your show. It's very good.
Thank you.
Okay.
All right. You're listening to Ask an Attorney. That's me, all about Florida law. If you have a legal question or just a problem, hey, give me a call. 877-943-9673. 877-943-9673. Phone lines are open. Let's go to Debbie in Tampa.
Hi, good morning. How are you?
Good morning.
Yes, I have a friend whose husband went into the hospital for about 5 days, and then he was transferred to a rehab facility where he stayed for 2 months, and then he passed away. While he was staying there, the facility was trying to get him approved for Medicaid, but since he passed away before the approval, they sent his wife a financial release form to sign, giving them access to her bank account and all financial information for this whole year of 2021.
I hope she didn't sign that.
I have two questions, yes. The first one was, should she sign the form?
No.
So you answered that one.
No.
And the second question was, can a wife be held financially responsible for her deceased husband's medical bills? They did have a joint checking account.
Well, the joint checking account automatically went to the spouse upon death.
Okay.
And no, a spouse cannot be held financially responsible unless she contractually obligated herself by signing something. So they might be trying to attempt to get her to sign something now where she gives access to the account and makes herself responsible for the debt. If for anyone else listening, if a spouse gets put in a position of having to sign something, then he or she has their spouse's power of attorney. They should always sign it with putting POA, power of attorney, behind their name and not individually.
Okay. We didn't get the power of attorney. That's what we were trying to do, and he passed 2 days before that was signed. So there is no power of attorney. So
Okay.
I was told that this form was, called a financial information release, and I was told that it was to go ahead and get the Medicaid approval so possibly they'd at least pay for his copay over there. But when I saw the dates, they want this released from January to December of 2021. I was like,
Now, who is they? Is that the facility?
The facility where he passed, yes.
And are they seeking any money from you directly?
No, they have not tried that. There's just one. It's just one paragraph that says, "I hereby grant permission and authorize any bank, building association, employer, insurance company, real estate company, government agency, or any financial institution of any kind or character to disclose to any agent of the Department of Children and Families full information as to my bank accounts, earnings, insurance policies, property, or benefits for the time period listed below." And this release is valid from January 1st, 2021 to December 31st, 2021.
And they told you the reason that they want you to sign that is to obtain the Medicaid government or Medicare government benefits?
Approval. Mm-hmm.
Approval?
Yes.
And how much do you think the bill is at the nursing home there or rehab?
I'm not sure. I know for the month of January they were saying it was around $5,700, and he was there 2 months.
Well, it might be. I'd have to probably process that a little bit more and actually see the form. And I do have a Medicaid attorney that might be able to advise you on that and whether you should proceed with that or not.
Okay.
In fact, his name is John Frazier.
Okay.
And if you want to call our office and chat with him a little bit, maybe he could advise you on that. But so the office number is, you're calling from Tampa, so 727-586-3306. And you'd go to extension 104 and ask for Mr. Frazier. He could probably walk you through what they're trying to do and whether you should sign that or not. It might be that you would, just to get the government benefits, if you're not personally obligating yourself on anything else.
Okay. Very well.
Be aware that if you give all that, though, and they find out that you don't qualify for Medicaid benefits, then you just make sure you don't sign anything where that makes you personally liable. That would be my concern.
Okay.
All right?
Very good. Thank you so much.
Thank you. You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen. We're more than halfway through the show. If you'd like to call the show and ask a legal question, you have a toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. Let's go to Alfredo in Sarasota.
Hey, Joe.
Hey, good morning.
Good morning. How are you? I enjoy your show very well.
Well, thank you.
This is a question I have about a creditor default that I did over 10 years ago. Yesterday, I made arrangements over 8 years ago to pay this creditor, which I default, and we agreed on terms. So the question I have, yesterday, I've been paying $50 every month. I set it up with my account at the bank, and they withdraw automatically. So I left it like that for 8 years. So I given them, it was a $5,400 settlement that we did. I got divorced, long story short. I settled some accounts, so I've been paying them. I had some setbacks financially. In the contract that we settled, after a year, I was supposed to give them $100. Then after another 2 years, $200, that kind of settlement. Well, yesterday I wanted to call and find out what my balance is. So they're telling me I owe them $4,200. So what do I do at this point where I'm giving them already $4,800? I asked them first, how much have I paid you in the past 8 years? And they gave me the number, which is about 4,800. I wrote it down. I have to look
What
at
kind
it.
of interest?
However,
Are they charging you big interest rates and service fees?
4.6%. So that's, I'm like, wait a minute. I mean, I know I had a contract with you guys and things happened. I didn't come through with the $100 and the $200, but every month for 8 years, I've been paying you, and I cleared $4,600, and the amount was $5,400 that I had to pay you. So what do I do at this point that I pay them for 8 years? Could I just give them the difference, send them a check for the difference plus their interest?
Well, do they have penalty fees and other? Because the interest wouldn't be that much.
Yeah, they have up to $200 to $400. I wrote it down. I think it's like $400 of fees and what have you.
In 1 year? And that's each year?
Well, I guess I have to ask that. I didn't ask if it's
Yeah, I think I would
year.
want a full accounting of their extra charges.
Yeah.
I mean, a 5% interest, a 5% rate of interest on $5,000 is only like $250 a year.
Yeah,
I mean, it's not a big number.
Exactly.
So where did they come up with all these extra charges? They must have big penalty fees that are not. Tell them you want to see everything in writing, and you want to have your attorney look at it. Tell them this is wrong. You shouldn't owe more than you started out with when you made all these payments every month with a 4.8% interest rate or whatever it is. So.
Yeah, and when I called them, they said still $4,400.
Yeah, that doesn't sound. Something doesn't sound right. They're charging too much on late fees, penalties, assessments, or whatever they're doing. It doesn't sound right to me. I would demand a full inventory or full accounting of all of the expenses of how they've accumulated those.
Gotcha. So itemize everything that they've done through 8 years in the process.
Yeah, and if you have, I don't know what your financial situation is, but you might try to refinance the thing to get rid of them and have a more reasonable deal going on.
I mean, I agreed to pay them, and I get it. We had a contract, and whatever things happen, and I didn't comply with their $100 after the first year, $200. I mean, it's whatever. I just set it up with my account, and $50 every month went in there. But after 8 years, so I'll do that. And if anything, do you do this kind of legality work?
Well, I have an attorney in my firm that might help you with that. So see what you can do, and then if you can't get to the results you want, let us know, and we'll see what we can do for you.
Okay. Well, thank you so much, Mr. Pippen.
All right. Thank you. Let's go to Denise in Seminole.
Hi, I ordered some things online, and I ordered 2 items, and they sent me a free item that has cost me tax and postage and handling. I want to return everything. Am I responsible for the shipping and handling for all of the items, just the 2 I ordered, and none of them?
Depends on, did they send you a return slip? And depends on the reason you're returning it?
No, they did not send me a return slip, just an invoice.
Well, I would ask them for a return slip, postage-free return slip, and see what they say. Then you'll have your answer, basically, whether you have to fight for anything else.
Okay. Thank you.
All right. Thank you. Let's give you the number. We have 14 minutes left in the show. You have a toll-free number, 877-943-9673. Phone lines are open. Let's go to Mabel in Tampa.
Hi. This is Mabel. I'm 87 years old, and I want to ask you a question about my will. I want to make my will out such that it's a 55-45 thing for my house. And the reason I want to do that is the 2 people I want to give my house to are brothers. And one brother sort of acts like a big brother, and he takes over a little bit. I want the younger brother, who gets 55%, to be the executor of my estate. Now, the question I'm asking is 45-55 a problem with the state of Florida? Does it have to be 50-50? And
no, there's no problem with 45, 55, 45. There's no problem with 90, 10, 70, 30, 60, 40.
For a house, for the house alone, not the whole estate, but just the house.
Let me tell you this. Most of the time, two things come to mind. Number one, usually the house would be sold, and then the proceeds would be divided 55, 45. It's not that they're going to own a house together, live together, and one owns 55, 45. So usually things get liquidated and turned to cash. Is that not what you want?
I imagine that the younger brother will live here for a little while. He already lives here.
Well, you could put in your will or trust. We'll talk about that in a second. You could put in your will, though, since you mentioned will, that he'd have the right to live there for a year. And then thereafter, it would be, liquidated and split. The proceeds would be split 55, 45. You could do something like that if you wanted to.
Yeah, I could do that. Yeah, that sounds good. Yeah.
One could buy the other one out.
Right.
There are all kind of things that could happen, in your plan. Do you know, though, your will? Do you know that your will's going to go through probate?
It probably will.
But you could choose not for it to and do a trust.
Right. I've not done that. It's so far I've just had a will.
Yeah, I'm just talking about your options with you.
Okay. No, I do have to change it because I do have it set up as 50-50 now. But I want to change it's time now for me to change the will around.
Yeah.
So I'm going to make some major changes. And I know that I can talk it over with the lawyer that does my will. However, I wanted to have some idea ahead of time so that I could. So I can do 45, 55. That's my question.
Yes, ma'am. Yes, ma'am. You can. All right. Thanks for calling. You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The phone lines are open right now. We have about 10 minutes left in the show. And if you have a legal question, you have a toll-free number, which is 877-943-9673. That's 877-943-9673. I wanted to tell you that I'm available to do seminars, starting to get speaking engagements again in person. If your group's not ready for that, I also do Zoom seminars to groups. And there's no charge for that. And a lot of times we get a little meeting going on with Zoom attendees. And we can talk and open up the chat room and take questions from your group and answer questions and so forth. There's no charge at all for that. I've had a couple of church invites to speaking engagements, so doing physical in-person meetings in churches now as well. If you need a speaker for your group, I'm more than available. There's no charge. Glad to do that. You have a toll-free office number to call no matter where you are. We have offices. We have 15 office locations all around Florida. We have several in Pinellas, several in Polk, several in Hillsborough, several in Pasco, offices in Leesburg, the Villages, Clermont, offices over in the St. Augustine to Jacksonville area. We don't charge anything for first office appointments to come in to discuss matters, and definitely don't charge for an appearance at a speaking, either Zoom or in-person speaking engagement. I'd like to call the office. It's 1-800-226-3529 is the toll-free number to call the show. I'm more than glad to help you. Again, if you have a legal question, the phone lines are open. You have a toll-free number, 877-943-9673. And again, phone lines are open right now for your legal question. Why worry about it? If you have a legal question that's bothering you, maybe you lost sleep last night, maybe just something keeps nagging at you, this is not right. And even if it's not a legal question, again, I'd be more than glad to help you. 877-943-9673. Phone lines are open. Let's go to Ben in Tampa. Hey, Ben.
Yes.
Yep, go ahead, Ben. Ask your question, please.
Oh, okay. Well, it was a comment about the water runoff, the earlier caller.
Oh, yeah, I'd love some help on that question. What do you have in mind?
Okay, so I'm a residential contractor, and to my knowledge, you cannot develop a property and have water run off onto the adjoining neighbor's properties. So the county would have to have EPC sign off on it. So the Environmental Protection Commission, and they're usually really nice people, and they just want to do the right thing. And he could go that route to have the EPC department of the county building department look at it and say, well, this has been an unintended consequence of what they've done. And usually they have silt fences up, so to prevent that, the sand would back up to the silt fence and then divert the water, in a certain direction. And I know Marion County is hilly, and you can't really see the whole property if it has vegetation on it and everything. So there's been some unintended consequences. The county has to go back, and if the county building department won't help him, then he needs to check with the EPC and have them send a letter to the developer or the property owner. Yeah. And
all right. Well, I think a good real estate litigation attorney would probably know all that, and hopefully. So if he can't get results himself, then that's pretty much what I told him. But Jeff, if you're listening, there you go. You have a little bit more information to help you. And Ben, thank you so much for calling.
You're welcome. You have a great day.
All right. Thank you. Let's go to Barbara in Clearwater.
Well, my mom passed in 2018, and I was the executor of her trust. In 2019, I sold her house and followed the trust and dispersed monies as she wanted. And I haven't done her taxes yet. Am I in big trouble is my first question. And my second question is, we moved to Florida from Illinois. Is there a way I could do her taxes here, or do I need to go back?
Well, the taxes are federal tax return, so it's not a state. So where you are doesn't make any difference.
Okay.
Did your mother die in Illinois?
She died in Illinois, yes.
So I'm not sure about what the Illinois state tax is. I mean, I practice in Florida, so I don't know the tax laws in all 50 states. So there might be a problem with the state taxes, but the federal tax return is federal. That could be filed anywhere. You as the trustee, personal representative of her estate, would be liable for the tax return being done properly. So if you distributed all the money and there's no money left to pay taxes, that could be an issue where you might have to ask for some help from the beneficiaries to reimburse you any tax expense. Normally, the selling of real estate does not create an income tax. The property gets a stepped-up cost basis at time of death, and then can be sold and liquidated and distributed without any further income tax. So their taxes could be nothing to worry about, but I definitely have somebody check into it.
Okay, thank you.
All right, thank you. All right, let's go to Bill in Sun City Center. Bill, are you there?
Yes.
What can I do for you? Yes, sir. What can I do for you?
I have a wife who's a resident of New York State. Can you set up a trust for somebody who's not out of state like that?
Yes, sir. Well, I can if they're in my presence. I mean, if she was, even though she's a resident of New York, if she would come to Florida and I could meet with her in Sun City, where I have an office too, by the way. I can.
No, she is in Sun City right now.
Okay, sure. Well, I can create a trust for somebody who lives in another state as long as they're in my presence.
Oh, great. Okay, I didn't know if it would be legal, if you have to go through the hoops to get it.
No, if you're a New York resident and you're residing in Sun City Center, you don't have to go back to New York to have an estate document done. It could be done right here in Florida. So.
Wonderful. We're going to make an appointment.
All right, great. Thank you.
Okay, thank you. Bye-bye.
All right, let's go to Brandon in Tampa. Brandon, are you there?
Are you talking to me, Danny?
Yes.
My name's Danny.
Oh, Denny. Okay, Danny. Go ahead.
Danny. Hey, sir, I have a question. How you doing today?
I'm doing great, and you?
I'm pretty good. I have, I've been trying to buy me a gun, for the home, and I have this misdemeanor domestic in Las Vegas since 1997, and I've been wanting to try to get it, like expunged or sealed, but they only do it, I think, expunges in Las Vegas. Is there anybody or someone I can contact over there that you will know that I can talk to about having that
Yeah,
done?
I know. I did a Zoom seminar on gun law, and the gentleman I did it with was Hunter Chamberlain, and he's very knowledgeable about that. If you want to email me, I'll send you, I will forward your email to Hunter and have him respond to you. Just put your name and phone number in it and send me an email to Joe, Joe, at ATTY
I'm sorry. Say that again.
Joe at ATTY PIP P like Paul, IP like Paul.com.
Paul?
Sir?
PAUL? Oh.
PIP.com.
PIT.com?
P as in Paul, IP as in Paul.com.
Oh, PIP.
All right, Danny, I hope I helped you. Let's go to Frank in Jacksonville.
Yes, hi, I love your show. Part legal or philosophical question. COVID terror. If a store that's open to the public, even though it's private, cannot discriminate for all the reasons, why, if I go in, I have trouble wearing a mask, and yet they, as you know, most of the stores in Florida, places in Florida require a mask. Could I assert that under the free access to the public or verbiage, et cetera, that why do I have to keep wearing this mask?
I think
when the rest of the state is open, bars and restaurants.
Yeah, I think if the store has its own policy, they can enforce that policy for the safety of others.
Well, suppose they say, gee, I don't want a black person to come in, or I don't want a Muslim
that's discrimination.
To come in,
I mean, there are laws on discrimination.
Well,
there are the laws on discrimination in age and things like that, but not, I don't think if they're not discriminating if no one can enter the store without a mask on. They're treating everybody the same. Hey, Frank, I've got 45 seconds left.
Okay.
I've got to end the show, but thanks for calling. You're listening to Ask an Attorney all about Florida law. We're on every week at 7 or at 8 o'clock. 8 o'clock on Saturday mornings. They repeat on 570, 910 in Tampa. They repeat the show Sundays at 5 o'clock. If you'd like to know more about Ask an Attorney all about Florida law and the different radio stations and shows that we have, you can go to our website, www.attypip, those are P's like Paul.com/radio. And you go right to our radio page that tells you about our shows. I want to thank you for listening to Ask an Attorney all about Florida law. And so if you'd like to contact us further, if you like one of our Zoom seminars, we did several Zoom seminars on wills, estate planning, trust, probate, Medicaid, gun law. If you like those, you can just send me an email request, and we can send you the one or all of them. We'll send you the links to all of them if you like. We did make a little YouTube channel of all of those, and you can do that to Joe, Joe, at ATTY PIP.com. Just send me an email to Joe, Joe, at ATTY PIP.com, and we'll send you a link. If you'd like our free estate planning poster sheet, the poster sheet is a full-size poster sheet on 5 articles on one side with wills, trust, information, probate information, how to avoid probate information, all of our office contacts, attorneys, website, radio shows on the other side of the sheet with phone numbers for local offices. If you'd like that, just send me an email. I'll be glad to mail that to you as well. And that is at Joe at ATTYPIP.com. That's Joe at ATTYPIP.com. Hey, you have a great weekend. Thanks for listening to Ask an Attorney all about Florida law.